Hi, my name is Gennady, and I'm an attorney with the Law Office of Yuri Moshes, which focuses on labor and employment matters. Today, I'm going to speak for a few minutes about New York's labor laws as they relate to meal and lunch breaks. Most ordinary workers are aware that New York state lunch break laws do exist, but many are often confused about the extent of their rights under the law. Meal break laws in New York protect workers by requiring their employers to give them at least 30-minute break periods for meals, but not everyone always takes a meal break. Sometimes we're so busy in our work that we skip lunch by choice. Sometimes a work schedule is so packed that we hardly can find a minute or two to have a sip of coffee, much less sit down and have a full lunch meal. However, the point of the meal break law is not to force meals on anyone, but instead to ensure that all the workers have a right to take that break if they choose to do so. Section 162 of the New York Labor Law Code explicitly requires employers to give meal breaks to all employees who work at least 6 hours. The law was enacted as workers' rights measure to help protect employees from abusive employer practices. Employers used to require their workers to work straight through the day without a lunch break. But such policies are not only cruel, they are unhealthy and potentially dangerous. Malnourished workers tend to be more exhausted and are more likely to make mistakes while on the job, which could result in injuries. All private and public sector employers and their employees who work in New York State are covered by the law. However, where you work will determine how long a break you receive. The New York Meal Breaks Law contains different requirements for factory workers and non-factory workers. Generally, a 60-minute uninterrupted lunch break. Non-factory workers are entitled to a 30-minute uninterrupted lunch break. In addition to the required lunch meal time, all workers are also entitled to an additional 20 meal break between 5 and 7 p.m. for workdays that extend from 11 a.m. to after 7 p.m. Meal break law violations are more common than you might expect, and even some major corporations that generally have good reputations break the law. Note, your employer is not required to compensate you for the time you spend while eating lunch or a meal. This is because meal periods that meet statutory requirements are not required to be counted as hours worked, and employees are not required to be paid for such time. On its face, Section 162 of the New York State Lunch Break Law seems very simple and is easy to understand. As long as non-factory workers are permitted to take the 30-minute lunch break, the employer has met the requirements of the law. However, many are different in the workplace, and it is often difficult to know how the lunch break laws in New York will apply to a particular situation. As employment attorneys, we are asked the same lunch break questions over and over again, and so we hope that by addressing many of these common confusions here, we can provide you with a quick answer without having to call an attorney for advice. Can my employer force me to remain on the job site during my lunch break? Well, while an employer may not be allowed to force you to eat lunch at your desk or at your station while working, there is nothing in the law that requires that an employee be permitted to leave the work premises for meal periods. So as long as the employee is completely freed from duties during the meal period, an employer can require you to stay on the job site during your lunch break. For example, an employer can require employees either bring their own lunch or eat in an on-site cafeteria or in a designated break room. Is my employer allowed to end my lunch break early due to staffing shortages or another workplace emergency? Under the New York State labor law, employees are entitled to at least 30-minute lunch breaks without exception unless the employee voluntarily waives his right or her right to lunch. This means that it does not matter that there are staffing shortages or emergencies making it difficult for the employee to have lunch. They still have to follow the law. Walmart was actually successfully sued over this type of violation under a similar California law several years ago. But the law is flexible, and an employer can reassign your lunch break to anywhere within the 11 and 2 p.m. window. In other words, if you normally eat lunch at noon, but due to staffing shortages, your employer is asking you to take your lunch at 1 p.m. instead, that type of scheduling is permitted under the New York meal break law, you can take your lunch period later. Can an employer take lunch under New York state law? Brown bag lunches are where employees eat their lunch while listening to a speaking or some sort of presentation. The topics for such lunches may be work-related or not work-related. Health and wellness issues and personal finances are good examples. All employees must be allowed an uninterrupted meal period, as we have covered already. So if your employer is teaching you during a brown bag lunch something that's unrelated to work, they cannot force your attendance unless your employer also provides you with an additional break from lunch if you choose to take it. Even if a meal is served at the brown bag lunch event, your employer must pay you for your hours as though you were performing your regular job. But employees who voluntarily choose to attend such lunches and topics are receiving a meal period under the law, do not have to be paid, and are not entitled to an additional lunch break. Now, can my union bargain away my right to take a 30-minute lunch? The answer is actually yes. If you are a member of a union and you are bound by a union collective bargaining agreement, a union can bargain away your lunch period where your employer needs extra time working and all of the union employees received some benefit, such as a higher pay, in exchange for the bargain. Now, is my employer breaking New York State lunch break law by rounding the starting and stopping time of my meal breaks? No, not necessarily. Rounding of time is a practice where employers will round the beginning and/or end of a shift or a meal period to an interval. For example, rounding occurs when an employee arrives at work at, let's say, 8:02, and the time records note that the employee arrives at 8. The department follows the principles set forth in the regulations with regard to the rounding of that time. That regulation recognizes that rounding is commonly accepted in industry and intervals ranging from 5 to 15 minutes and permits such rounding. Extending the rounding regulation to the meal period requirements is proper, so long as rounding of starting and stopping time for the counting of meal period requirements does not, over a period of the time, result in a failure to provide employees with the required meal periods. In short, rounding of time is permissible as long as it does not result in employees losing time. If I waive my right to take a full lunch period and instead take a 15-minute break, does my employer have to pay me for the time I spent eating? The short answer is yes, but there are caveats to this rule. Your shorter 15-minute lunch break period is most likely categorized as a short break under the labor laws rather than an actual lunch period. While the New York State labor laws do not require that employers provide rest periods of short duration, if they are provided or taken by employees, they must be counted as working time. Can I substitute my lunch time for an early release from work before my shift is done? Generally, no. Remember that a lunch break is defined as a 30-minute window between the hours of 11 a.m. and 2 p.m. Foregoing your schedule will allow you to leave at 4:30 instead of 5, because it is outside of the statutory time window. With that said, if you and your employer do agree to such an arrangement, that is absolutely acceptable unless the agreement takes the form of a long-term contractually binding arrangement that could result in the employee being denied proper lunchtime if he or she wants to have one. Does taking a coffee break affect my ability to take a lunch break? Fortunately, no, it doesn't. Lunch breaks are entirely unrelated issues legally from short breaks, bathroom breaks, and coffee breaks. New York State's short break laws do not actually provide substantial worker protections. No employer is actually obligated to give an employee any short break at all. This is one of the many reasons why the lunch break is so important, because it might be the only allowed break during the day. Unfortunately, the practice of depriving employees of their earned lunch breaks is widespread, and we would love to have the chance to hear your stories. Know your rights under New York law and do not neglect them. If you feel like you have been wrongfully denied a meal break, you should act to protect your rights and hire an experienced employment law attorney to evaluate your claim. The Law Office of Uri Moshes is a full-service employment law firm focusing on labor law violations, workplace rights, wage theft, and employment discrimination claims. Our law firm operates in the New York City area and provides all employment law clients with a free to help you to evaluate your case. You can reach us at 718-504-6090, or you can visit our website at www.mosheslaw.com. Now, this video only pertains to New York State employees and not to any other state. If you have questions in regards to your employment rules and laws in other states, you have to seek the advice of local counsel. Thank you.